constitutional declaration by the Supreme Court of India help the LGBTQ community? Will a declaration that marriage is a constitutional right and not merely a statutory right help the cause of the LGBTQ community who are fighting their case at the Supreme Court of India? And more importantly, should the matter be left to the will of the Parliament or to the committee that the government was earlier talking about? What are the broad options before the Supreme Court of India? All these questions we tackle in this edition of Let's Talk Law. All the questions that I just mentioned continue to dominate the proceedings at the Supreme Court of India. This is yet another day in the hearing at the Supreme Court. All the arguments, all the questions are being discussed at length about making a constitutional declaration that right to marry is a constitutional right. It's not merely a smaller right or a statutory right, what you call. Now, what is the meaning of a statutory right or a constitutional right? Let's first tackle the core demand of the petitioners and the LGBTQ community, seeking a constitutional declaration. Now, what is a constitutional declaration in the sense of the LGBTQ rights, and how is it going to help the community? This is the core demand of the petitioners. That's what exactly they're seeking. Now, constitutional declaration, it means clarifying that a certain right is fundamental in nature. Well, the right may not be explicitly mentioned in Constitution or the chapter pertaining to fundamental rights, but the court declares it to be a right protected as a constitutional one, which means Parliament or a statute cannot take it away. Statutory rights are rights, but they are lesser in status. They can be taken away by a law or by the Parliament. Constitutional rights, on the other hand, they cannot be vitiated by the elected legislature. They are protected. For example, privacy is a fundamental right. It was clarified by the Supreme Court that the right is implied, all-pervasive, in part with the Constitution. Now, the petitioners are saying similar declaration need to be made for the LGBTQ right. Marriage is a fundamental right linked to dignity, liberty, and equality in the country. Let's discuss the options that the community has and what are the options that the Supreme Court is basically looking at right now. The first, seeking a constitutional declaration. I just explained what a constitutional declaration means. Now, this means that the court declares, in this case, marriage to be a fundamental right. Right to marry as a constitutional one, you cannot deny it just because somebody is a same-sex couple or a homosexual couple. Once the Supreme Court makes a declaration of this nature, that marriage is a fundamental right, all existing laws, statutes linked to will, adoption, inheritance, property, I'm not even going to the personal laws right now. All these statutory laws will have to be aligned. Amendment, changes will have to be made into it. Across the world, there are certain democracies where this kind of approach has been taken. No law, no statute will be able to take away the rights of the LGBTQ community. The harmonization process will have to happen through amendment, changes, scrapping, court intervention. So let me give you an example. So suppose there's a law which is about adoption. And in that particular law, it is said that same-sex couples cannot adopt. Somewhere it's implied. So either the Parliament, after this declaration by the court, will have to repeal the law or change the law, bring an amendment, or somebody can go to the court and challenge it. This kind of process will happen once marriage is declared as a fundamental right, or right to marry anyone is a constitutionally protected one. But yes, there's a huge gamut of personal laws, which is the issue. I've spoken about it earlier, that personal laws stand in the way of the LGBTQ rights. Marriage in Muslim personal law, in Christian personal law, in Parsi personal law is completely a religious concept. And here the implied sense is that marriage is a union between a man and a woman, and there's very limited extent to which the courts can actually go into that territory. Now, this particular declaration is the highest form of constitutional protection that the community can get from the apex court of the country. So that's broadly about constitutional declaration, what does it mean for the community and how it goes forward. Option number 2 before the court. Certain petitioners argue that, all right, marriage equality, perhaps we are not legally ready for it. Give us certain civil rights. Right to sign on each other medical form, bank accounts, adoption, certain civil rights that we need as individuals to operate in the society. Now, these civil rights will not be marriage equality. These civil rights would largely be about ensuring that same-sex couples are able to live their life with certain sense of equality, dignity, acceptance, without any kind of legal hiccups. So the second option is largely about granting certain civil rights, and in this option, this would fall short of the equality, the equality of marriage between homosexual and heterosexual couples, but it will grant the community certain rights. What is the second option? Well, this second option, as I said, is something short of a marriage, recognition of a civil institution. Interestingly, this approach was taken by many countries, including UK. If you look at the trajectory of how different countries have done, in fact, in UK, US, there is a whole movement that was there, socially and culturally and legally as well. There was a step-by-step approach that was taken, that a civil partnership was, first legally recognized, and then they graduated to a full marriage right for homosexual couples. Certain civil rights will be granted. Absolute equality is something for now will be given a go-by for the homosexual couple if option 2 is exercised. Now, these civil rights can be granted by the court or by the government. You remember that the government has proposed setting up of a committee, and this committee can look at the various issues, have some interdepartment negotiations, have discussions with the petitioners, and then they can come up with some options. So the grant of a civil institution is something which is the government and the court both can do it. But let's see if they're open to that option. The petitioners, there are multiple petitioners before the court. All the petitioners were not happy with this option. This is a middle ground of sort. While the third option is leave the matter open-ended without any relief for a later day for better times when the law is ready. As we move forward in these hearings in the days to come, we have discussed the broad option, option number 1, option number 2, option number 3. But what is to be really watched out is that will the Supreme Court limit itself to the Special Marriage Act, the Hindu Marriage Act or the Foreign Marriages Act, certain laws that have been challenged, or it's going to declare it as a constitutional right. If it declares it to be a constitutional right, if the court declares it to be some degree of having a fundamental right in nature, the right to marry, then it essentially means that for some day, the matter of personal laws will also countenance the Supreme Court of India. The hearing is underway. These are the broad options which are being discussed. But getting the declaration of a constitutional right is the highest form of relief that the petitioners can get from the apex court of the country. Thank you for watching.